Good morning everyone. This is Kamikawa Kaelin. Lie like exhaling, is this. It is a word that accurately expresses the state of ghetto, telling lies without any confusion. The other day, a large number of Chinese people have flowed into Obihira City, Hokkaido, and they are illegally receiving welfare protection. Information such as was sent on SNS membership exchange site. After all, this is completely hoax information, and Obihira City shows the actual receipt status on the homepage. I denied the information. Many of the posts quote footage from TV shows that were previously broadcast on Twitter. About 8% of the Chinese who are flowing into Obihira City are welfare recipients, he said. Some say 13,000 Chinese people are on welfare in Obihira. There was also incorrect information. According to the status of receiving welfare protection based on the statistics of foreign residents in the country shown on the website by the city, as of June 2020, 4,805 people have received the benefits throughout the city, of which 8 are Chinese nationals. On the other hand, there are a total of 91 Chinese living in the city, and the ratio of beneficiaries is 8.8%. Compared to 118 Chinese residents as of June 2015, it has decreased. There was no fact of mass inflow or fraud. But why are foreigners receiving Japanese welfare protection? I think everyone wondered. Therefore, I investigated the current state of livelihood protection in Japan and its problems. I would like everyone overseas to know the current situation in Japan. Originally, Japan's livelihood protection system was the constitution, and the law stipulate that it should be paid to the Japanese people. In Article 25 of the Japanese Constitution, people have the right to live a healthy and culturally minimal life. Guaranteeing a healthy and cultural minimum life for the people as it was a national obligation. Livelihood protection is a system for citizens with Japanese nationality. It is not supposed to be paid to foreigners. Article 1 of the Japanese Public Assistance Act states, this law is based on the philosophy stipulated in Article 25 of the Constitution of Japan. The country provides all the people who are in need of living with the necessary protection according to the degree of their need. The purpose is to guarantee the minimum standard of living and to promote its independence. It has become. According to the 1946 Public Assistance Act, after the war, we adopted the principle of indiscrimination inside and outside the country, which is applicable to all residents. When it was revised in 1950, by adding a nationality clause, we have created a system in which only citizens can receive the benefits in the first place. Even though the law was amended, it was limited to Japanese people. Why is it applied to foreigners as it is now? This originated from the Ministry of Health and Welfare issuing a notice in the name of the Director of the Social Affairs Bureau on May 8, 1954. The title of the notice is, About Welfare Measures for Foreigners Who Are in Need of Living. At the beginning of the notice, about the measures to protect the lives of foreigners who are in need of living. I'm sure that even if you are in your position, you will not miss it. The handling procedure and procedures have been organized as follows. I want you to be aware of this and make every effort to implement it. Then, he states as follows. According to Article 1 of the Public Assistance Act, hereinafter simply referred to as the law, foreigners are not subject to the law, but for the time being for foreigners who are in need of life according to the handling of the decision implementation of livelihood protection for the general public, we will provide protection deemed necessary by the procedure on the left, hereinafter omitted. Actually, the for the time being mentioned here as until now, it has continued without being reviewed. That is the cause. Speaking of pity, until then, in other words, Japanese and foreigners are treated in the same way. This has continued without being reviewed even once after the war. So why is such an important notice without any amendment to the law? Only by the administrative judgment of the name of the Director of the Social Bureau was it decided suddenly without deliberation by the Diet and without checking? Don't you think it's extremely unnatural? Examining this reveals ridiculous facts. What is the background behind these notifications? This was due to the entry into force of the San Francisco Peace Treaty in 1952. Koreans, and Taiwanese who remained in Japan under the rule of Korea and Taiwan. It has a very close relationship with the fact that I lost my Japanese nationality and fell into statelessness. The rights that had been naturally granted as a Japanese citizen by the rule of Korea and Taiwan until then, due to the circumstances of Japan, I suddenly lost it. If you become stateless, you will not be paid the benefits paid to the former Japanese soldiers of WW2, participation in the national pension is not permitted and there is no pension. Therefore, even those who became Korean or Korean nationals needed the same legal protection as Japanese citizens. That's why. But there is a backside to this. It was said that there were some circumstances in which such a notification had to be issued. At that time, in 1952, during the Korean War, South Korean President Syngman Rhee January 18, just before the San Francisco Treaty came into effect April 28, 1952, he suddenly set up a Syngman Rhee Line that imitated the MacArthur Line, and he declared Takeshima a Korean territory and unilaterally included it in the Korean waters. South Korea at that time was in the midst of the Korean War. Many Koreans have fled to Japan as stowaways. The number is said to be 200,000 to 300,000. On the other hand, Japan has been disarmament under the occupation of GHQ. The Coast Guard was not available. South Korea is trying to consolidate Takeshima's sovereignty with the unilaterally declared Syngman Rhee Line. As the boundary line, he continued to capture Japanese fishing boats, saying that he had crossed this boundary. A total of about 4,000 Japanese Takeshima fishermen were abducted because they were said to have crossed the line. 8 of them were killed. The detained fishermen will experience hell from the desire to proceed with the negotiations to normalize diplomatic relations between Japan and South Korea, which began in February of the same year. The Korean government used it as a diplomatic card for Takeshima fishermen. Negotiations were, of course, difficult. South Korea it would be a problem if many Koreans who fled to Japan during the Korean War were deported from Japan. Furthermore, it is difficult to recover the huge amount of Japanese assets in Korea, which is said to be $5.3 billion. That is why I used Takeshima fishermen as hostages for this purpose. This kind of sneaky way of the Korean government. Ambassador Douglas MacArthur too, who was the U.S. ambassador to Japan at that time, he criticizes it as barbaric hostage diplomacy. Under these circumstances, the Japan-Korea Basic Treaty was signed. Some of South Korea's demands include not only the abandonment of Japanese assets in South Korea and the refusal to accept Korean residents in Japan. It also included secret agreements such as the release of Korean political prisoners and claims for livelihood protection. Until the 1965 Japan-Korea Fisheries Agreement abolished the Syngman Rhee Line, the capture of Japanese fishing boats by the South Korean Army continued. The period is up to 13 years. The number of detainees, the number of ships captured and the number of casualties until the abolition of the Syngman Rhee Line are: number of detainees, 3,929; number of captured ships, 328; number of casualties, including casualties, 44. The Japanese government has to get them back. He paroled Korean criminals in Japan and even gave him a special residence permit. It is said that the number of the criminals is as high as 472. And the secret agreement even included this claim for welfare. Then, how many foreigners are currently targeted? Looking at the Ministry of Justice statistics, 1,375,296 people could be eligible in 2010. Of these, 484,025 people have Korean nationality, which is the largest number. Among them, the number of special permanent residents is overwhelming at 395,234, which is 99% of the total. How many foreigners in Japan are actually receiving welfare protection? According to the ministry, the number of households receiving livelihood protection in 2016 was 1,637,045, including Japanese. Of these, 47,058 households were headed by foreign nationals. Of these, most households have the nationality of Korea. It accounts for 28,996 households, about 66.2% of all foreign nationals. Next is the Philippines with 4,902 households. China has 4,443 households. Brazil has 1,532 households, all in 2011. China is growing rapidly. 6 years ago, there were only 2,609 households, but it has increased 1.7 times. What is worrisome is the ratio of livelihood protection households to the total households. The average of Japanese people is only 2.6% of all Japanese nationals. South Korea and North Korea account for 14.2% of all Korean national registrations. The Philippines is also 11%. The number of households receiving livelihood protection among all households registered in South Korea and North Korea as 14.2% stands out by an order of magnitude. According to the Ministry of Health, Labor and Welfare, the foreigners who are eligible for the benefits are the status of residence as in Appendix 2 of the Immigration Control and Refugee Recognition Act. In addition to permanent resident, Japanese spouse, etc., permanent resident spouse, etc. The explanation is that special permanent residents are also included. In Japan, Korean Peninsula's smugglers, who escaped from the North and South Korean War, after the end of the war 200,000 to 300,000 people have arrived. The special permanent residents of Korean and Korean descent include many stowaways after the war. They, the first generation in Japan, even if the North-South Korean War ceasefire continued to illegal stay in Japan. The director of the Ministry of Health and Welfare at that time said that it was a special measure against the law. Treating these Issei who came to Japan in hopes as refugee equivalents, we issued a notice to local governments nationwide to provide livelihood protection. At that time, it was a dimensional measure for the first generation in Japan. The second and third generations in Japan claimed that it was the right that their ancestors Issei in Japan had won. Today, up to the fourth and fifth students living in Japan are on welfare. The number of Japanese welfare recipients is 1 in 50. The percentage of Korean residents in Japan who receive welfare benefits is 1 in 5. Also, looking at the National Treasury contribution of welfare expenses on a project cost basis, the total protection cost in 2012 reached 3,628,452.4 million yen. Over the last 6 years, it has grown by nearly 1 trillion yen. Since the Democratic Party of Japan lasted 3 years and 3 months, just during this time, you can see that it is growing rapidly. And the provision of livelihood protection to foreigners has reached 120 billion yen annually by our estimation. And among the households registered in South Korea and North Korea, 142 out of 1,000 households receive welfare protection. It is in a prominent situation. Again, special permanent residents are a system originally started to help stateless people. Some of these people because some people were not allowed to join the national pension and became non-pensioned. It is a system that was unavoidably taken. However, after that, the special permanent residents were not limited to these first-generation people. Similar rights have been extended to the second and third generations, and I think the number of non-pensioners is now probably quite low. With these points in mind, I think we have to rethink the system itself. In this way, despite Japan providing 10 times more protection to South Korea than Japan, South Korea has a special law on national attribution of pro-Japanese anti-ethnic actor property. There is a Japanophilia prohibition law, called. It is a law that was passed in 2005 as if it authorizes hate speech to Japanese people. The law recognizes hostility to Japan as the will of the nation. Indeed, they are being returned with gratitude. Even though such a situation is actually born in Korea, people with nationalities of such countries, why do we Japanese have to be tax protected? If they are naturalized to Japan and have Japanese nationality, I know. However, as my own intention, I did not naturalize to Japan. Those who want the nationality of a nation that is hostile to Japan and pledge allegiance to South Korea. Those who want the nationality of a nation that is hostile to Japan and pledge allegiance to South Korea. Though why does Japan have to use Japanese taxes to protect it 10 times more generously than the Japanese? Isn't this something that everyone thinks? Isn't it strange? Even so, isn't the rate of receiving livelihood protection outstandingly high in both South Korea and North Korea? While saying unfounded swearing to Japan, isn't it too dependent on Japan? Isn't it in a state where it can be left as it is? Above all, you lose your trust in the welfare system, right? Social rights such as livelihood protection, it is at the discretion of the state and is not obligatory. For liberty, whether you are a citizen or a foreigner, you must be equally guaranteed. However, Social rights vary depending on the financial situation of the country and are decided by the will of the country. Even if you look at other countries, there are many different guarantee contents and guarantee conditions. I have never seen a country that gives preferential treatment to foreigners, including Koreans. Needless to say, we should eliminate the application of welfare to foreigners in order to eliminate them. It is never the case. On the contrary, without relying on non-legal administrative decisions, the protection of foreigners is another law that has been deliberated by the legislature. I want to justify it, fairly, and tell you to do it. Livelihood protection is a system for Japanese people, so foreigners should not be targeted. However, apart from livelihood protection, if a foreigner suddenly has trouble living, allowing measures similar to livelihood protection for a certain period of time, we will make such a law and protect foreigners fairly with legal grounds. Isn't that a necessary idea in this corona disaster? Let's stop making administrative decisions that have no legal basis like we do now. I would like to make a suggestion. What kind of opinion do you have? Please comment by all means. That's all.